Good afternoon, Doc Jesse Martinez, and to all my classmates under our subject, the Juvenile Justice and Delinquency. This video presentation is especially made for the purpose of my report relative to the subject matter that I am presenting, in order for us to understand the indeterminate sentence law on how or why the penalty imposed in lieu to the appellant's case. Likewise, I would like to inform everybody for the purpose of privacy and sensitivity, considering that there was a minor involved in this case, so I'm not gonna mention the appellant's name. So, the ISL or the ISLAW or the Indeterminate Sentence Law, an Act number 4103 was passed by the Philippine legislatures and approved way back December 5, 1993. Old but gold, ika nga. A very old law but still very applicable and very useful to our Philippine criminal law and justice even up to this day. So now, what are the significant features of this law? Under Section 1, the ISL is applicable to two types of offenses. First, offenses punishable by the Revised Penal Code, and second, offenses punishable by the special law, which is apparently applicable to my selected case, considering that the anti-rape law is fall under the Revised Penal Code, and likewise, the Republic Act 9344 or the Comprehensive Juvenile Justice Act of 2006 is fall under our special law. Note, however, that the ISL does not apply to those convicted of the following offenses. Offenses punishable by death, reclusion perpetua or life imprisonment. Treason, conspiracy or proposal to commit treason, misprision of treason, sedition, rebellion, piracy, and those convicted by final judgment with an imprisonment of not exceeding 1 year. Likewise, the following are also not applicable to ISL. Habitual delinquent, those who escape or evaded sentence, those who have been granted conditional pardon but violated the conditions set forth of that conditional pardon, and lastly, those convicted by final judgment prior to the approval of the ISL. So meaning to say, there is no retroactive. Accordingly, if the ISL is applicable and the crime is punishable by the Revised Penal Code, an accused, after found guilty, shall be meted an indeterminate sentence law composed of a maximum term which shall be what should be prescribed by the RPC after taking into consideration the attendant circumstances, and a minimum term which shall be within the range next lower to that prescribed by the law for that offense. And if the offense is punishable by the special law, an accused shall be meted an indeterminate sentence law composed of a maximum term which shall be not exceed than the maximum term fixed by the said law, and a minimum term which shall be not less than the minimum term prescribed by the said special law. Under the Revised Penal Code, except for death and reclusion perpetua or life imprisonment, which is basically not applicable to ISL because it needs to impose in its entirety, the other penalties are divisible into three periods: the maximum period, the medium period, and the minimum period. This maximum, medium, and minimum period, which are flashing now in our screen, which I believe that lots of us are familiar with. Now, the imposable penalty shall depend on the presence of either aggravating circumstances or mitigating circumstances. The rules are provided under Article 64 of the Revised Penal Code. But for the purpose of brevity and simplicity, as far as my case presentation is concerned, we will summarize it as follows. Assuming there is aggravating circumstances and there is no mitigating circumstances, impose the maximum period. And let's say there is mitigating circumstances and there is no aggravating circumstances, impose the minimum period. And when there is no aggravating circumstances and likewise no mitigating circumstances, impose the medium period. So what if there are both aggravating and mitigating circumstances? So let them set off against each other. So let's say there is 3 aggravating circumstances and 2 mitigating circumstances. So 3 minus 2 is equals to 1. So impose the maximum period. So let's say there is 2 mitigating circumstances and 1 aggravating circumstances. So 2 minus 1 is equals to 1. So impose the minimum period. So let's say there is 3 aggravating circumstances and 3 mitigating circumstances. So 3 minus 3 is equals to 0. So impose the medium period. As simple as that. Now, let's try it to the appellant's case. Ngayon, para maintindihan talaga natin kung ano yung nangyari sa ating appellant or sa ating subject matter, considering nga na minor siya, because basically, yung original penalty na binigay sa kana is reclusion perpetua, which is life imprisonment, at indivisible siya. Kumbaga, i-implement siya in its entirety. So, sabi ng batas at sinight ng Supreme Court, considering nga yung ating appellant was only 17 years old when he committed the crime, he is therefore entitled to the privilege of mitigating of minority under Article 68, Paragraph 2 of the Revised Penal Code, which provides that the penalty to be imposed upon a person under 18 but above 15 shall be penalty next lower than the prescribed by law. So meaning to say, yung originally reclusion perpetua, which is indivisible at hindi siya pasok sa ISL. Ngayon, sabi ng batas, next lower degree. So magiging reclusion temporal. Kasi nga minor siya. Reclusion perpetua, reclusion temporal. So dito sa reclusion temporal, next lower degree, ito daw, sabi ng batas, ito daw ang magiging basehan ng kanyang maximum period of penalty. Maximum period of penalty ng kanyang ISL o yung indeterminate sentence law. Pasok to siya sa indeterminate sentence law kasi nga divisible. Pag sinabing divisible, nahati siya. So sa batas, nahati into 3. Merong tinatawag na maximum, medium, at minimum period. So tatlo yan sa iba-bracket natin. So etong reclusion temporal, dito daw ang magiging basehan ng kanyang maximum ng kanyang indeterminate sentence law. So it's either sa maximum period, medium, minimum. So bawat duration nito meron siyang length, particular length of period of penalty. Tapos, sabi naman ng batas at sinight ng Supreme Court, para daw to determine the minimum period of its indeterminate sentence law ay again next lower degree from reclusion temporal. So, para ma-determine daw yung minimum period ng kanyang indeterminate sentence law, again, next lower degree ng kanyang penalty. So, from reclusion temporal, next lower degree is prison mayor. So, prison mayor. So, ito daw ang magiging basehan ng kanyang minimum period of penalty ng kanyang ISL. So, ito yung basis ng kanyang maximum period. Dito naman kukunin ang medium period. So, likewise, indivisible din siya. Meron siyang maximum, medium, at minimum period. So, ngayon, ang binigay ng Supreme Court sa kaso ng ating appellant, sabi dito, since there being no modifying circumstances attendant to the crime, the maximum of the indeterminate penalty should be imposed in its medium period. So sabi ng Supreme Court, inimplement or ang inimpose ng Supreme Court sa ating appellant ay kukunin daw ang kanyang maximum period penalty sa medium period ng reclusion temporal. So ang medium period ng reclusion temporal, ito minimum, medium, maximum. So ang medium period ng reclusion temporal is from 14 years and 8 months and 1 day to 17 years and 4 months. So, isusulat natin. Medium period. So, ang medium period is from 14 years and 8 months and 1 day to 17 years and 4 months. So, dito daw, kukunin ang kanyang maximum period of penalty. At ang kanyang minimum period of penalty ay kukunin daw sa full range ng prison mayor. So, ang full range ng prison mayor ay from 10 years and 1 day to 12 years. So, sulat natin. Maximum ng prison mayor, 10 years and 1 day to 12 years. So, ito yung magiging minimum period ng kanyang penalty. At ang 14 years and 8 months and 1 day to 17 years, ito naman ang kanyang maging maximum penalty. So, ngayon, with regards sa imposable penalty, kung 14 years ba or 13 years ba, so long as pasok dyan, depende na talaga yon sa court. It is entirely upon the court kung ilan ang ibibigay niya. Pero as far as the case of our appellant is concerned, ito yung binigay ng court. Ang kanyang maximum period of penalty ay kinuha sa medium period ng reclusion temporal at ang kanyang minimum period of penalty ay kinuha sa kanyang maximum ng kanyang prison mayor.